is relevant to my client's case. This could be a precedent. Where has that case been before? Well, that which you're probably reading, right? Let's say it's an appellate decision. Where is that case? Exactly. In other words, every case that you read is going to have been in the trial court. Because appellate courts don't have original jurisdiction. You can't start there, right? So when people are having trouble doing case brief or understanding a case, I will ask them, what happened at the trial level? And many times they're like, I don't know. So the procedural history is basically what happened at the trial level. Not factually, procedurally. Did the court enter a summary judgment? Was there a judgment on the pleadings? Was it a non-suit? Did it go to a verdict? What procedurally happened at the trial level? Very important that you look for that and know what happened. Who won and who lost? You need to figure that out. Otherwise, it's hard to figure out what's going on. So that's what we call procedural history. What did the trial court decide? Sometimes you have to look for it, but they will tell you. The next thing, what we call the key facts. This is hard for some people because they want to put everything. So you want to figure out what makes this case unique. Some people are adamant that dates are important. Sometimes dates are important, sometimes dates are not important. Depends, so we're going to work on that. The key facts, basically a nice little paragraph that sums up what's going on with this case, more or less. So we'll work on that. Then comes what's called the issue. Keep in mind that when people appeal cases, they appeal it on one or more issues, correct? And the issue is the same with almost every case that you read. How can that be? I'm telling you that the issue is the same in every court case that you find and have to read. How can that be? What's the same issue?
Yeah, they're disputing basically what happened in the trial court.
Right, so if you say, did the trial court err, you've got half the points on your issue, because that's the issue in every case. Did the trial court err? Because the reason people appeal cases is they feel what?
Yeah.
The trial court error. So now what you got to do is to try to figure out what specifically did the trial court supposedly err in. That completes your issue statement. So the issue statement is generally in question form, and it is always pretty much, did the trial court err in, now you got to find the question. And sometimes they give you the issue statement right there for your taking if you're looking for it. And that's the central question that the court is looking for. And then you've got your holding. You've only got three options in the holding. What are they?
Affirm.
Yep.
Deny.
No.
No. Affirm.
Affirm, reverse, or remand.
Yeah.
So affirm means they don't find any error. Everything stays the same, your appeal is denied. Reverse means they find error and they reverse the decision. Remand means they send it back down with direction to do something, or to fix something, or to have a retrial on something. And then the last part is what we call the reasoning. And the reasoning is simply why. So if you look at it like a logical question, why did the court hold the way they did on this issue with these facts? And because will never be the answer for reasoning. The court will tell you why they held the way they did. They have to. And they want to because they want the reasoning of the court to be used in the future. So they want to share it with everybody. They want to prove to you they're not idiots. They want to prove to you that they looked at prior decisions. So they will tell you why and what was the factors that made them do that. So this is what we call the reasoning. And if you're looking for it, and this is what happens is, after you do a couple case briefs, you start to look for this stuff as you read the case. And I tell people this, and the light doesn't come on sometimes for a few times, but basically every one of these court cases is written the same way. So even though you might not understand the section of it, you know where you're at, the reasoning, or the holding, or the procedural history. And if you work through it, you can literally take a 10 to 15 page case, boil it down to one page, and now let me ask you the question. Once you get good at finding cases, reading them and briefing them, and this is for you, then how would you do with this thing? Frame it?
Yeah. Save it in mind.
Can you repeat, what was the holding next to the case?
The holding is affirmed, reversed, or remanded. Well, the case brief properly done is going to set you up for your next job, because remember, we don't find and read these cases in a vacuum, just for fun. It's usually because our client has a problem, right? So this case brief is going to be your aid to helping you create a product. In legal research, when you go to the library and do your research and analyze it, you don't have an oral exam with the lawyer. You submit a product. Your research can go in a demand letter, your research can go in a motion, a complaint, an answer, a memorandum of law, and you're usually given the job of putting your research into one of these products. And when you get into legal writing, having a case brief is very, very helpful. Better than even trying to highlight in your book. Because some people need a paintbrush. I see some of your books, everything's yellow. You look at the stuff that's not yellow? So, I guess basically I want you to change your attitude about case briefing. Although it says on page 93, the importance of cases in our common law system has already been discussed, right? Yes? And it says it's not sufficient to merely read a statute assuming that will provide the answer. You generally need cases because statutes are vague and ambiguous. I like though what it says, few people find it natural to read cases. Thank God. You're one of the few people. It says the writing style is archaic, it's made difficult to comprehend, the topics discussed sometimes are complex, and so on and so forth. It goes on to talk about law students, lawyers, judges, and all the stuff that you do. So we're going to work on it throughout the semester, and I'm going to all make you, I want you all to be comfortable with case briefing and say, yeah, I can do it. I'm not afraid of it, I know what it looks like. But that being said, I don't think we should start off with a 50-page U.S. Supreme Court case. I think we need to take smaller steps and focus on single issues so you kind of see what we're looking for. So, a lot of this stuff we're going to revisit in Chapter 4. Like I said, we're not done with that, and we'll finish that in our next class, not Monday, but next week. And before our library tour, I do want to mention, even though we're not covering it tonight, Chapter 5. Chapter 5 is on page 107. When you go into the library, I want you to keep one thing in mind, that cases are published chronologically, which creates a big problem for research. So that means when you walk up to Cal Reporter, or Pacific Reporter, or the California Reports, and you see all these books with numbers on the binding, if you pick up any one of those books off the shelf, and you start looking at the cases in there, are there any rhyme or reason to how they're in there? It's chronological, which means murder case, work comp case, family law case, which is murder right now. Personal injury, breach of contract, they're all messed up. So there's not one book on drunk driving, there's not one book on torts. It's how they come off the press. So any book you pull off the shelf is just a mess. So, it's a variety, exactly. Well, as a researcher, if you have a specific issue, you want to bring all the cases on contributory negligence together. But that may mean this book, and that book. So, what they have invented is this thing called the digest. The digest is not primary or secondary. One of the few things in the law library that doesn't fit neatly into primary or secondary. A digest is quite simply a tool to find cases. And a digest, quite simply, arranges cases by topic. So, after President's Day, we're going to explore how to use a digest. Because if you're going to find cases that are relevant to your client's problem, you have to know how to use a digest. The digests are the keys to the car.
Yes.
Because unless you have a site that you can go into the library to book number 15 of Cal Reporter and go to page 682, you're screwed.
You
If
cannot
you walk
find
up to the cases, they're all messed up. So remember that the digest is a tool to help you find cases by arranging cases a number of ways.
It's like an index,
By
actually.
topic. Exactly. The one thing I want to remind you of, though, is there's not just one digest in the library. So, for example, we said that California cases will be in Cal or CalApp, Pacific Reporter, and Cal Reporter, right? That means digest, digest, digest. If you publish cases, what must you also publish? The keys to the car. So that means when you're in the library and you see the word digest, it finds cases. What's it find cases in? It depends. On the federal level, we said that district court cases are in the federal supplement, appellate court cases are in the federal reporter, right? So they came up with something called the Federal Practice Digest. And you use the Federal Practice Digest if you wanted to find lower federal court opinions. U.S. Supreme Court, we have the U.S., we have the Supreme Court Reporter, and we have the Lawyer's Edition. Guess what? Digest, digest, digest. If you make reports or reporters, you got to make a digest, which means there's not just one digest in the library. So part of what we're going to do on Wednesday is we're going to see that there are a lot of digests, and you're going to see those. And I just wanted to introduce that to you because we're going to talk more about it, and we're actually going to cover this chapter. But since we're going there, I wanted you to make you aware of that. I would also encourage you to reread Chapter 4. Now that we've covered what we did, I think Chapter 4 will be a little easier to understand and have some sort of relevance. And then when we finish it, go back again, because as I said, there are a lot of questions on the midterms in Chapter 4 because it is such an important chapter.
Are you gonna have a sign telling us where to go Wednesday? You like,
Yes.
arrows or something?
No, I just one floor, I'll be there.
Oh, okay.
Yeah. They have both one floor, but the main floor is, it's pretty hard to hide in there.
Is this another quiz?
Again, this is why we have.
Like another quiz?
Oops, sorry.
Okay, so this is assignment number 1. Some of this can be done at your leisure because it doesn't require the library. And then on the back page, you're going to have to do some library stuff. Keep in mind 1, 2, 3, 4, 1, 2, 3, and 4 you should recognize that site. That's Cal Reporter, right? Not Cal out, not Pacific Rule Word, Cal Reporter. And so that will require the library. So the first page you can do on your own, that covers a lot of chapter 3 on statutes and chapter 2 of the court system.
Can we do iTunes and do it on the computer?
As long as you stay put it up here. I don't care. As long as it's there. The next one that I'm handing out to you, 1, 2, 3,
How was your first day? Yeah. Very good. You're welcome.